What are the key components or elements that should typically be included in a stipulation of settlement agreement for a divorce case in New York State?
The basic elements are that you want to address how property is going to be divided. So, I'm defining property for now being co-ops, condos, plots of land, houses, etc. So you want to address, whether title is being changed or if that issue is being deferred, for how long it's being deferred. I've unfortunately seen some agreements that come in where they just say, well, eventually the parties agree to sell the house, and it doesn't set a date. And the problem there is if it's left open-ended, then it's very hard to enforce when one party wants to sell, or if there's going to be a buyout now, or when the buyout should occur. So you want to address all of that. You also want to address who's going to pay all of the expenses in regards to the property pending that sale or buyout. So that's also essential. Sometimes I see agreements come in that, oops, missed that. And then one party or the other says, well, gee, there's taxes due on the residence, and I want the now ex-spouse to pay half. And the ex-spouse says, well, gee, it's not in the agreement. You're living in the house. You pay the taxes. And it just invites further disagreements on down the road. So you really want to craft your divorce settlement agreements to address every conceivable issue that may come up, so that you don't invite lawyers back into your life. Those are kind of the issues with regards to real property. You also want to address all aspects of quote unquote personal property and financial assets. So you want to address every single bank account, whether it's joint or quote unquote sole bank account, what's going to happen. Sometimes there's, people don't realize that, oops, my name is on an account as an authorized user. And if the agreement does not address that the other side will agree to take their name off as authorized users, then you do the agreement. You may have a disagreement on down the road where somebody says, well, gee, I didn't agree to that, and the agreement doesn't even address that. So I'm not going to cooperate in that. Then you want to address the disposition of all investment accounts and all retirement accounts. Particularly in regards to retirement accounts, you want to address, okay, if there's going to be a qualified domestic relations order, who's paying for that? When is it being submitted? Sometimes it's advisable to even agree going into that on the Quadro drafting service that the parties are going to use, so that they can literally just hit the ground running after the judgment is signed to make sure that that gets done. Then you want to address, if there's children involved, you have to address custody, visitation, child support, and how all that is going to work. The more specific you are, the less likely there's going to be a disagreement on down the road. So in high conflict cases, you really want to have a very lengthy agreement that's going to spell out every aspect of how decisions get made, what's going to happen in the event of a disagreement. You even want to put in timeframes on when those issues are going to be addressed. So as but one example, if the parties are going to do what's called the professional model on joint custody, and that's where presumptively they'll defer to the recommendation of the given professional on a particular decision that comes up in the child or children's lives. With high conflict cases, you want to set in a deadline, let's say 3 days, at which the other side has to respond to the triggering email that proposes the decision. And you want to say in the agreement, if they don't respond within those 3 days, their input on that decision is deemed waived automatically. You are also well advised to have an app, whether it be Our Family Wizard or Talking Parents or Two Houses, to facilitate communication in high conflict cases. You'll want the agreement to specifically address, um, that that's going to be done, who's going to pay what on the app, whether it's going to be divided equally. I know Our Family Wizard even has proposed language that one can incorporate into the settlement agreement itself, to then address all the particularities in terms of the implementation and use of the Our Family Wizard app for joint custody cases. And then with respect to child support, you want to address all different permutations of child support, not only basic support, but also all of the add-ons. So all of the add-ons means unreimbursed medical, unreimbursed childcare, unreimbursed educational, and what all those terms mean. You want to spell out in your agreement so that somebody doesn't say, well, gee, I don't consider eyeglasses to be a medical. I mean, that's usually commonly falls under the rubric of medical, but some people that, especially in high conflict cases, they may say, well, gee, in my mind, medical means doctor, and that's it. So I'm not going to pay for the eyeglasses. So you really want to spell out examples of what those terms mean, as well as whether it covers things like cosmetic surgeries, nose rings, earrings, etc., piercings or whatever. You want to address all different aspects of that. You also want to address things like extracurricular activities. Not only who pays what, but then in the joint custody section, whether there has to be agreement on that. If there's a proposed activity for the child, you should say parents not to discuss that proposed activity or the decision-making process with the children until the parents have decided amongst themselves that the activity is warranted. If you're going to implement a parent coordinator in a joint custody agreement, you want language in your agreement that says that. Now, in New York, what I often recommend is to go onto the court system website. This is how I do it when I'm implementing a parent coordinator. I just grab the language from the model order that's on the court system website for implementation of a parent coordinator. I believe off the top of my head, one of the model orders is from the quote-unquote 8th Judicial District, which I think is technically up near Buffalo, but it's equally applicable throughout the state. That's just the one that happens to be on the court system website. And I just extract all the language and obviously modify it based on the particularities of any case. But you want to address that. Now, you also want to address maintenance, otherwise known as alimony, how that's going to work, when it's going to end, under what circumstances, if ever, it can be modified up or down or terminated. So you want to address all different aspects of that. And then you want to, there's a lot of boilerplate language that should go in, such as estate articles. You want to address things like, insurance, medical insurance, life insurance. You may need to address things like whether there's a step down of life insurance, such as, as the children age, maybe somebody doesn't need to keep life insurance to secure child support at the same amount as they originally put in to the agreement. So you could step down, like, let's say you start at $1 million, you step down after 5 years, you go to 750, and after 10 years, you go down to $500,000 or something like that. But that's usually, you want to put in a sufficient amount into a life insurance policy to cover each parent's share of basic child support, the add-ons that I alluded to earlier, as well as their contribution towards college. And you want to even price out the possibility that they may go to private school and build that in. If both parents went to private school, the likelihood is that the kids are going to go to private school as well. So you don't want to hamstring the child to have to go to a state school, especially if the parents are high income. So those are the basics.